Well, this is a podcast from Artist Rights Institute. My name is Chris Castle. I'm a music lawyer in Austin, and I'm a director of the Institute. And today we're going to talk about some of the more legal, if you will, aspects of releasing a record. So we're going to go through a few assumptions, which are that you have recorded this record yourself. You're not signed to a record company, although some of this will still apply even if you are signed to a record company, because they may expect you to deliver some of these items that we're going to go over. There is a checklist, which I'll make available as part of the show notes on the website, the Artist Rights Institute website. And it's a fairly extensive checklist. So we're going to go over all the items. So if it seems like I'm following along a specific path, it's because I am. And I suggest you do the same. It'll make it a little bit easier to understand and to know when you want to start and stop to get further clarification. So I'm going to walk you through this, just a little bit about me. I have been practicing since 1987. Hopefully I've learned something since then. My work has been predominantly in the music business, and a good chunk of that time I spent working at A&M Records and at Sony, where I dealt with this kind of thing all day, every day, right? So after that, I did a lot of production legal for outside, as an outside lawyer, for example, for Austin City Limits and other productions, soundtracks, soundtrack albums, and many of these same issues you have to deal with when you go to deliver a soundtrack album, or they'll be a little bit different, but they'll be pretty much the same. So this is a good basic checklist to work from. It will stand you in good stead, I think, for any one of a number of situations, creative situations. So let's get started. We're going to start with sound recordings. This will be divided up into sound recordings, songs. The high level will be sound recordings and songs, and then the people who do the work on all these copyrights. These are copyrights. Each one is a separate copyright. Remember that. Sound recordings are a copyright. Songs are a copyright. Can be owned by the same people or different people. Can be owned by the same people or different people in the same country or different countries. So it's something to keep in mind, that unless you have it written down and signed, you don't really know what you own. So let's start with the basics here. If you are a group artist, then you may or may not have any accompanying musicians, often called sidemen, or side artists. You may have a guest artist. You may have someone who comes in to sing a vocal or play a guitar solo or comp in the background, for that matter. All those people who are not part of your band are employed by you. And there's a concept in copyright law called work for hire. This is getting into the detail about what is work for hire is a little beyond the scope of this podcast. But let's just say if you have a work for hire form, then you have quieted the title in whatever that sound recording is. So you want to make sure, if you have any guest artists, sidemen, anyone of that nature, to step out, someone who's not part of your group, someone who's not the licensed, or the not the license, but the owner of the copyright, then you will need to get a work for hire form. That's also going to be important if there are musicians who are, let's say, union members. If you are a union signatory, then you'll file union paperwork, and that will take care of the issue. Or if you're not a union signatory, and many of you will not be, then you're going to need to get these musicians to sign a form, which does two things. It says you own the copyright, but it also says you don't owe them a royalty unless you've agreed to pay them a royalty, which you don't have to. If they're sidemen, they're probably not expecting that. But you need to have that tied down, quieted down. Another group of employees that you may have will be producers. You need to have a producer agreement for each producer. And that would include any band members who are producing, who are also producers. Now, that's a special case where the band member is producing, and you may or may not have addressed that in your band partnership agreement, for example, or whatever band agreement you have. So you need to check that and see if there's any provision in your band agreement that says a band what happens when a band member produces. But the basic producer agreement is something which producers will expect to have, and that will dictate whether they get a royalty, and then whether they get an advance against that royalty, and how that advance is recouped. The detail on that is beyond the scope of this podcast, but we have another section in the financial education vertical that deals with producer agreements. So just scroll down and you'll find it. And then we'll eventually do a podcast about producer agreements. It's a much more complicated topic. Now, along with the producer agreement goes something called a producer declaration. A producer declaration is another form of work for hire agreement. And it's sometimes required by your record company. If you're signed to, particularly if you're signed to a major label, they will almost always ask for a producer declaration. And you're going to need one from each producer, mixer, and potentially engineer, depending on how involved the engineer is. So with engineers, I would just assume that you have to have some kind of document that shows how they've been engaged and whether or not they're supposed to get a royalty. This is important because people get selective memory disease and they decide later, oh yeah, they promised me a royalty and I never got it, right? So get that tied down. Other artists who perform on the record, such as guest artists, side artists, we talked about a little bit, or what's called a step out, which is where a guest artist might sing part of the lead vocal. Those all need to be documented. And if they're signed to another label, then those artists need to be cleared. And this is not anything new. Everybody's going to know what it is. Side artist agreements are very common at a record company. So you're probably better off to ask the label, what's called the home label, which is where the label that the artist who's stepping out is signed to, ask them to give you a side artist agreement. And there may be some bells and whistles in there, like they get to use the track downstream or something like that get your attention. But most of the time, it's just a straight up clearance where they allow the person to participate, but they want what's called a courtesy credit. And you need to know, because we're going to get to this later, when you go to deliver your credits, courtesy credits are one of the credits that you're supposed to deliver to your distributor, which could be TuneCore or it could be, Warner Music Group. So make sure you know what the courtesy credit is. And that will usually be in the form of, Jane Smith appears courtesy of the big major record company. Simple as that. But they want it. So they want it for another reason, which is they don't want to create the impression that somehow their artist is actually signed to your label, which might be the impression people get if there's no courtesy credit and there's just a credit for the artist. Right. So make sure you have that covered. If you are part of a group, then you got to make sure if you have a group agreement, like a band partnership agreement or a corporation, however you've set it up, that you are clear about how this recording fits in that agreement. There could be a side letter if you don't have one, if you don't have an overall band partnership agreement, but you need to be clear about it because eventually this is going to be important. Um, One of the things you need to do is you need to register as a featured artist, and if you own the sound recordings, as a sound recording copyright owner with Sound Exchange. And when you go to register with Sound Exchange is going to ask you for a number of what are called metadata items such as uh, track name, artist name, and at a minimum the International Standard Recording Code, which we'll talk about. That is a separate registration that you have to do with Sound Exchange. That's separate and apart from your distributor. Now, if the recordings are marketed as featured artist and the group name, right? So in other words, Jane Smith and the Awesome Band, right? You need to determine what that means. Because you may or may not be paying the Awesome Band a royalty split. And if you're not, then you need to document that you're not. This is going to come up with Sound Exchange registrations as to who is the featured artist. And that's an important thing. That's also going to come up depending on how you collect your international neighboring rights. You're going to need to give this information for those registrations as well. And if it hasn't sunk in yet, making sure you get all your money is a process of chasing data, registering with this one, making sure they're not holding money for you because they don't know how to find you, etc. Right? So this is a much more involved topic for another day, but just understand that you're going to be expected to do all these registrations. You can't really rely on anybody to do it for you without supervision at all. And someone, either your manager, your business manager, someone needs to look after this, right, and make sure it gets done. Now, what's under songs? Songs are either written by the band, written by the artist, or co-written, or written by somebody else, right? In your record deal, if you have a record deal, there will undoubtedly be something called a controlled compositions clause. And what that means is that, particularly for vinyl or compact discs, there will be a limit on what the label is willing to pay for mechanical royalties. So let's talk about mechanical royalties for a moment. Royalties come in different flavors for songs in particular. Song royalties are usually either performance royalties, which is ASCAP, BMI, CSAC, GMR, and a couple others. A player to be named later, or they're mechanical royalties. And the difference, of course, is that the performance royalty is for the public performance of the song, which is radio, live, and a few others, or it's for the mechanical reproduction of the song. And that would include vinyl CDs and streaming. The vinyl and CDs are paid at a different rate than the streaming. Streaming mechanical royalties are paid kind of along the lines of streaming record royalties, which is where there's this pool and it's divided up. If you ask me, a terrible idea, a terrible precedent to set, but that's what it is. Control compositions clauses don't really apply to streaming. They do apply, though, to physical CDs and vinyl. And so this sort of, this is where a page of history is worth a volume of logic. Remember that there are limitations on the amount of recorded material that you can get onto a vinyl disc or a CD. And so that's kind of where this concept of controlled compositions originated. They would say, we're only going to pay for 10 songs, right? Well, 10 songs used to be sort of what an album was. Songs had a running time of 2 or 3 minutes in the very beginning, early days of the music business. And so, an album could easily handle, 10 3-minute songs, particularly when you had two-sided vinyl. CDs, I think the Red Book standard, if I'm not mistaken, is something like 72 minutes. So then people started wanting to record more songs. So then you got to 11, sometimes 12 songs on a disc. And the label would say, I'm only paying you on 10. Sometimes if you could negotiate, you'd get to 11, right? And maybe even 12. But there was a sort of a limiting factor there because it wasn't possible to get more than a certain amount of running time onto the carrier, the vinyl or the CD. So why do I mention this? There's another element to this, which is, again, a longer story, but the mechanical royalty rate is set by statute, and it's set by something called the Copyright Royalty Board in Washington. And the Copyright Royalty Board determines what the rates are going to be for all configurations, including physical. So they would have a rate, and the label said, well, I don't want to pay their rate. I'm going to pay less than their rate. You won't be surprised to learn. They didn't say, oh, I don't want to pay their rate, let me pay more. They didn't do that. So the way it ends up, the broad strokes of the controlled compositions rate, which is what you call it, is 10 times 3/4 of the minimum statutory mechanical royalty rate. And that every word of that matters, right? So the minimum statutory mechanical royalty rate is basically for songs of 5 minutes playing time or less. And if it's over 5 minutes, then it's basically prorated by minute for every minute or portion thereof in excess of 5 minutes. So you can see that this control compositions clause matters, right? Because if, for example, you bring in an outside writer and the outside writer says, I didn't sign your record deal, or more likely the outside writer's publisher will say, I didn't sign your record deal. I paid this kid a bunch of money. I intend to recoup it. I'm not taking the 3/4 rate, and I'm not taking the control comp cap of 10 songs. So I want full rate. And not only do I want full rate, but I want to be paid on all units. And that's the other thing that's in the control comp clause, is that they say that they only pay you mechanical royalties on units for which a record royalty is payable, which is a tricky way of saying, I'm not going to pay you on free goods. Well, free goods could be a substantial amount. I had one situation when I was at the record company where an artist had a #1 single, which in those days meant you were selling a lot of commercial singles. And SoundScan, which is what you use to track physical sales, is kind of like a relatively objective standard. showed that, let's say, 1 million units have been sold, but we paid on 700,000, right? And I got a call from the publisher saying, where's the other 300,000? I have an outside writer. To which I replied, the reason why the album really took off is because of the single. And one of the reasons the single really took off is because we gave away 300,000 units that those stores were able to sell. We didn't make the money. And so that's the reason why I'm not paying you for your 300,000. These are not easy conversations, right? But that's the kind of thing that can happen if you don't have this control comp issue tied down. Okay. And the label, to a certain extent, relies on both the artist to take care of it, because the artist is doing the hiring as a general rule and does the co-writes. But they also rely on their record company, record deal with that artist to protect them if those calls ever come in. So what they'll say is, well, if I can't get out of paying these additional royalties, then I will pay them, but I will charge it back to the artist as a recoupable advance, additional advance. And that's in the record deal too. Okay, just don't bother looking, it's there. So this is another reason why you need to get this tied down. So whenever you bring in an outside writer for a recording project, just remember co-writer, or a cover song, of a classic, you name it, Beatles, Johnny Cash, whatever it might be. There's a pretty good chance that those people are not going to take a reduced rate. So you're going to have to deal with that. There's not much you can do about that. There is something you can do about newly written songs with co-writers, and that is you make sure the co-writers understand they're going to have to take your control comp rate, and you have a document that says that, and you get that squared away up front. Of course, what goes along with that is splits, and that's the next thing that you have to worry about. Just because you think you co-wrote the song with one other writer doesn't mean that everybody who is involved in the process agrees with you, right? So you need to have the splits tied down as best you can from everybody who theoretically could have contributed. One of the things I like to do in producer deals, because the producer's the most likely suspect in this little problem, I like to get the producer to acknowledge either that a list of songs and splits that are attached to the producer deal are the songs and splits, or that he didn't write anything or she didn't write anything, one or the other, because that way I know what happened and I don't have to worry about this sneaking up on me later. And I highly recommend that you do the same, that you do something like that. So in summary, with co-writer, you have a split agreement. You have a fairly detailed split agreement. It addresses whether the co-writer is accepting your control comp rate. If that co-writer happens to be the producer, which happens sometimes, then address that in the producer agreement as well, and tie down what people did and did not do. Where this comes up, where it's touchy a lot, is if it's a group that has, their version of Lennon McCartney or Jagger Richards, right? Some people write songs and some people don't, but you need to have all that tied down so that there's no disagreements, because you really want to keep the friction low in the band, because there's plenty of opportunities for friction anyway, right? So don't let this be one of them. These are ugly conversations if they're not handled right. All right, so don't do this at the end, do it at the beginning. If the artist or the co-writers are signed to a major publisher and you want concessions from them, you should expect trouble from the publisher. because they're, like I said, they paid a bunch of money to sign this kid, and they intend to get it back, right? So they're not inclined to take, control comp. Now, where this comes up, where it becomes a problem is if you don't have this tied down, like, for example, who can quote on sync licenses and whether the band has the ability to grant gratis sync licenses. Because let me just back up. That sync licenses are like the third category of record royalties, right? Or excuse me, song royalties. And sync licenses are when you synchronize the song in timed relation with the visual image is the legal catechism. But basically, it's when you do a video, when you do a TV show, license for TV, when you do a music video, for your own band, right? So when you're starting out, and even maybe when you're not just starting out, these opportunities to do sync licenses are a big deal, right? And sometimes they're an important part of the marketing. We had a deal at A&M with the Aaron Spelling company that was doing at that time was doing 90210 and Melrose Place. And I was very flexible with the music supervisor, who was a wonderful person, for those shows. And I gave her, premium premium artists in return for premium placement. And I just sort of I just said, pay me what you can pay me, right? And she did. And she did. She was fair about it. But I didn't try to treat each one as an opportunity to soak her for every possible nickel I could get my hands on, right? You have to have a bigger worldview than that when you're doing this kind of thing, and it's got marketing benefits to you, right? So, like, for example, when one of her shows, I won't say which one, had its premiere of its final season, which was a heavily watched show. We had 3 A&M artists in premium placements in that show. That was good, right? We put that in the good thing category, right? But I had developed a relationship with the publishers early on, because the publishers can stop that cold, right? So I had that relationships with the publishers so they would play ball. In a band situation where you're not, dealing with a big show and a big record company, what you want to try to do is you want to say to the outside writer's publisher, look, I'm recording this. I'm creating value for you. I need to be able to do what I need to do with this for my band. If you want to argue downstream, for unrelated licenses, after I've had the record out for a year or two, and I'm kind of moved on to the next thing, and we're now talking about catalog, then fine. You can hold me up. I don't mind that. I do mind if you're doing it to me with my record for my release. So these are conversations that you want to have. You will need to know the names of the publishers and the administrators for each writer, because you're going to need to deliver that to somebody at some point. And then you're going to want to register with something called the Mechanical Licensing Collective, and with your PRO, which will be ASCAP, BMI, CSAC, GMR, in all likelihood, one of them. Or you could have a couple if you've got different writers and different ones. So that's kind of what you need to know about songs. And then we'll talk about copyright registrations, and then I think we'll close this podcast and we'll come back to artwork and some of the other things you need to deal with. So copyright registrations can get pricey, right? But I highly recommend doing the copyright registration for the songs and for the sound recording. Now, understand this, you do not have to do a copyright registration in order to have copyright. Copyright attaches at the moment of the work is fixed in a tangible medium of expression, as the saying goes. But in the United States, if you want to sue, for example, for copyright infringement, you'll need to have that work registered. So I like to register kind of the big stuff right away. And there are a number of the Copyright Office, which is copyright.gov, has some wonderful information up there. They're very good about this. I think they have webinars right now about how to do copyright registrations. But you can also look at the circulars that they have, which are kind of cheat sheets for particular topics. Circular 56 is for registering sound recordings. 56A deals with registering songs and sound recordings on the same registration. Circular 50 is for registration of songs alone. And Circular 45 is for registering videos. So this is a more involved topic, but you'll need to eventually have to deal with the Copyright Office. So no time like the present. Go check that out and get it done. They're a lot faster than they have been for many years. So I think they've improved their efficiency there. So it'll take a while. But once you register, you're in motion, and you'll get it as soon as it can be gotten. If you really are in a big hurry, a really big hurry, there is an expedited registration that's available, but it's expensive. If I'm not mistaken, it's something like $600 each one. So use that sparingly. If you plan this well, you won't need it. But it's the kind of thing you do if you're thinking you might have a lawsuit, right? But I just mention it in passing so that you know it's there. So we're going to call this now. Thank you for taking time to listen to this. I hope it's useful. And we'll pick this up again in the near future for the rest of the licensing checklist.